Morning, Chair.
Morning, honorable members. Morning, my apologies. I had some little bit of a hiccup.
Recording in progress.
Is everybody okay?
We good, thank you, Chair. And how are you?
I'm trying. I'm surviving. Day before yesterday, I had my shot. So well, but it's fine. Before we do anything, can I just establish from Mr. Sakaza if Ms. Isaacs has logged in, our parliamentary law advisor.
Yes, Chair, she's in.
Okay, thank you very much. Are all members in? That's what is going to be important. Are all our members in? Because on my screen I only see.
We are here, Chair.
Four. Mr. Sakaza, can you? But yeah, no, that's fine. You will at an appropriate time. You'll make a roll call.
Yes.
Honorable members, good morning. I hope we're all well. We are meeting at the time that the country has gone back to alert level 3 due to the challenges of third wave in other provinces. But what is important is that those that are above 60 should go for their jab, for their shot of vaccine. As we have listening to media, Gauteng has accepted the walk-ins, and we think that there are centers that open over the weekend. I think that is commendable. Because we are in a very challenging situation. But that does not mean because some of us have been vaccinated, which we have got a responsibility to empower and encourage other people to demystify the myths that are there. But it does not mean that we must not adhere to non-pharmaceutical protocols, wearing a mask, staying at home, social distance, go out if when necessary, washing our hands, and avoiding crowded areas. It does not mean that we are not to do that. So as public representatives, we have got also that responsibility. It's not only the responsibility of the command center, it's not the responsibility led by the president, it's not the responsibility of the Department of Health, it is the responsibility of all public representatives, because we are to save ourselves and we are to also save our neighbors, and by so doing, we're saving our families, our neighbors. By so doing, we are saving the society. And those with comorbidities, they must please ensure that they do adhere to all the protocols. On a lighter note, this weekend was going to be my daughter's birthday, and I was Dana, I was besek because it was going to be her 40th birthday. And when an announcement was made of alert level 3, I said, "Oh my God!" But he then said, "Well, I postponed it." I said, "God is great, because you don't know what these young people do." But I'm saying that also is a responsibility, that's leadership. And I told her that if you are going to continue with that party, I was going to be the first to call law enforcement to come and dispense you. That was on a lighter note. But to show honorable members the importance of us taking that role, that responsibility, that leadership in ensuring that we protect the country. Having said that, honorable members, we are going to allow Mr. Sakaza to take us through who is in. I'm going to also request members or to request guests to tell us who are they and from which institutions. And then after that, I will then outline how then we are then going to move today. Mr. Sakaza, can you take us through in terms of the roll call?
Thank you, Honorable Chair, and good morning to Chair and all the members present today. Chair, we've got today from the Portfolio Committee, we've got yourself, Chair, Honorable Junjwa, got Honorable Nkabane, Honorable Mbabe, Honorable Nonsele, Honorable Begram, Honorable Kado, Honorable Mkondo, Honorable Denner, and Honorable Ngobo. I received an email from Honorable Hinana saying that he won't be able to attend today, but he will be present tomorrow. That's the only apology I received from members, Chair. And then from the support staff, I've got myself, Committee Secretary, I've got the Committee Content Advisor, Sibongiseni Ngobo, I've got the researcher, Tibuho Mukwena. Shia, the Committee Assistant, is not present today. She has a problem with her child. Thank you, Chair.
Sakaza, before I go any further, I see Honorable Ngobo's hand.
Yes, thank you very much, Honorable Chairperson. Honorable Chairperson, I just want to mention that for the past 2 days, we haven't been having electricity in our area. It wasn't load shedding. They have a problem with cabling. I'm just holding my breath. I think I will pull through. But if I disappear, I will be trying again and again. Thank you, Chairperson.
Thank you, Mr. Ngobo. And from the department?
Sorry, Honorable Chair, I see Honorable Zuma just logged in, Chair. Honorable Zuma.
Okay.
Chair.
You haven't mentioned Ms. Isaacs.
Oh, sorry, Chair. Okay. Ms.
Okay.
Isaac, the Parliamentary Legal Advisor, is also present. Okay, thank you.
Okay. Can you please mute Honorable Ngobo? From the department? From the department, who is here? You can't tell me that there's nobody from the...
Honorable Chair, Thembinkosi Mkhaliphi, I'm in the meeting. I'm accompanied by Karabo and Thando Ababa from the Minister's Office. Thank you, Chair.
I'm of the understanding also that you're supposed to be accompanied by your legal person from the either department or ministry. Can we be clarified?
Well, Chair, I mean, maybe they are going to still come. I don't know. I don't have any information about that.
Okay. Can the parliamentary legal officer assist in checking that for us? Are there any guests?
Good morning. It's General Smith. I'm from PMG.
Thank you. Who else?
Good morning, members. All protocol observed. My name is Christopher. I am from the chairperson. I'm the chairperson of Kusatu in Swartland municipal area. Also a member of the United Labour and Development Forum in the Swartland municipal area. The United Labour and Development Forum comprises of a lot of stakeholders that deals with the issues of labour, particularly in the Swartland area and our farming areas.
Thank you very much. Is that in the Western Cape? Thank you very much, Mr. Mens. Are there any other? N. Mjekane? Who's N. Mjekane, Mr. Sakaza?
Natim Jengane Chair is the other parliamentary legal, but he is the one who deals with COID. I think he's just joining too.
Why is he not responding?
Good morning, Chairperson.
Morning, Mr. Mjekane. No, thank you very much, honorable members. It's my responsibility just to recap. Can you please mute Mr. Sakaza? To recap in saying, why are we here? Members will understand that a bill, after it has followed all its processes in the department and in the cabinet, it was then subsequently sent to the office of the Speaker, which then was a 80 seat for the committee to then look into the amendments. And what then the committee did, it listened to the department. The department tabled the amendments, explaining why they have to do that. And we then advertised for everybody to comment, which was then called written submissions. We had a deadline which we extended by 2 weeks. And after that, we then also opened up for oral submissions because community stakeholders, people with interest, have got that constitutional responsibility to do that. We listened to everybody. And having listened to everybody, we also requested the department to clarify or explain what was then raised in the written and oral submissions for us to then understand. And members will remember that I have always been cautioning members that we must ask questions of clarity, because we are to get questions of clarity. And that was a process that was preparing us, even when those people came, stakeholders, companies, individuals came and make presentation in front of the committee. Members will always remember that I always say, please be focused on a question of clarity, because that process is then a process that is now has to culminate to today for us to deliberate. And in the process of deliberation, we are going to go clause by clause, because we can't jump all over. We are to raise our views, why we are for this and why we are not for this. We'll debate as members why it is important, in particular for the law advisor, for parliamentary law advisors to be present, because we can't continue with them not being present, because they are the people that are to guide us. I am now then going to give over to Ms. Isaacs. Ms. Isaacs now is then going to just take us through what is the meaning of this and whatever, and why we should go clause by clause. What is then the outcome? What the outcome of this? What is meant by A list, and what is meant by B, and then so that as we move step by step, we move with that understanding. That is why the office of the chair saw it necessary, deemed fit that we must have 2 days per bill, so that we don't rush, so that members understand. It is the responsibility of the parliamentary law advisor, among other things. Obviously, it's not going to mingle in our political discussions, but it is her responsibility to caution us if he feels that we are going overboard, or what then we are then supposed to do. If we agree or we don't agree, that is not in her space, but hers is to guide us, so that if something arise in the process, and we what there are challenges, she must then be able to say, I did advise the committee on this and this and this. So that is why she is here. That is why I also I'm also a bit concerned that whether the department law legal team is not present, because in my communique with the parliamentary liaison officer in the office of the minister was to say to ensure that their legal team is part of the meeting. I see that there's somebody called Kaylen Monique S21. Can that person introduce him or herself? Please. Is he coming from, is he a guest? If a person does not want to introduce himself, I always have a serious problem, because after meetings, parliamentary committee staff is being harassed and bullied by people who are saying I was informed by my source, which was in the meeting. These meetings are of public knowledge, but we must know who is here, so that we clarify to that person, and that person says exactly what was discussed in the meeting, not what he or she thinks. So I would have a problem with this Kaylen, whose video is on, but he has muted himself, and he or she does not want to tell us whom she is. Having said that, let me then give Ms. Isaacs. Solani ngibani lo mntu ungafuna uzixela? No, he has decided.
I don't know, Chair.
He has decided to leave. It's fine. Ms. Isaacs, I see that we have been joined by Honorable Jacobs. You are welcome.
Greetings, Chair, and thank you for the opportunity.
Thank you. You're welcome. You're welcome. He is a member of parliament. Remember that members of parliament do have a right to log in whatever committee that they have got an interest. He's a member of the National Assembly. If there are some, even if from the NCOP, we must get that indication, but with an understanding that first preference in terms of deliberations will then be given to the members of the Committee of Employment and Labour. Can we then be taken through by Ms. Isaacs? And feel free, ma'am, to take your time, take us through to understand what is then expected of us, and then we will then, yeah. Who is this Kaylen, good people? Kaylen S21 Ultra. But it's fine, as long as he must switch off his video. He's not prepared to tell us who he is.
Hello, can you hear me?
I can hear you.
Yeah, I'm Chief Jan Liederman from Mamasbury, and I'm part of the Labour Forum.
Oh, all right.
Sorry, lady, because I've got difficulty with this phone, because it's my wife's phone and I don't really know how to work it, but I can see you hear me now.
Technology, fine.
Yeah,
As long as
new technology.
yeah, as long as you're going to mute, as long as you're going to mute yourself, please, because if you are unmuted, you are going to mess up. And Honorable. Oh, okay, Honorable Jacobs. Mute yourself. Over to you, Ms. Isaacs.
Good morning, Chairperson, members of the committee, and guests. My name is Sue Ann Isaac, and I'm from Parliament's Legal Services. I am assigned to assist the committee on this bill during the entire process, and especially I'll be here to help the committee with its deliberations. The chairperson requested me to just remind the committee of the process that it will now follow in deliberating on this bill. So I will refer the committee to rule 286 of the Rules of the National Assembly. And so far the committee has done the public submission process. They have given the department an opportunity to respond. And we are now at the stage in terms of Rule 286D, which is deliberations by members. So at this stage, the committee will now, in terms of Rule 286D, the committee will be doing deliberation by members, taking into consideration proposed amendments and comments and proposals received and evidence presented. So basically, the committee will be considering the public submissions, the department's responses, their own views of the members, and will be discussing the different clauses, and will come to an agreement as to whether they wish to change any of the proposed amendments or not. Once that is agreed to, in terms of Rule 286E, there will be a formal consideration of the bill clause by clause, including amendments as formally proposed. So this refers to a process where once the committee has decided on various amendments, we will draft what is called an A list. That is a list of all the amendments. The committee will then consider the A list. Once that is done, the committee will then adopt the B bill. The B bill is the bill that is produced after the committee's agreed to the proposed amendment. So that is the bill that the committee will consider, which will include its proposed amendments. So basically there's three stages: the deliberations, the A list with the proposed amendments, and then the consideration of the B bill, which is the bill that the committee will put forward to the National Assembly. So Chairperson, that is by way of process. With regard to the bill before us, it is the Employment Equity Amendment Bill, which is B14 of 2020. This bill seeks to amend the Employment Equity Act. So if members have copies of both the bill and the acts before them, it will be useful for them to see where the proposed changes are to be affected. The chairperson also asked me to just explain the technicalities. So if you look at on the second page of your bill, at the very top, it says a general explanatory note, and it says words in bold type in square brackets indicate an omission from existing enactments, and words underlined with a solid line indicate insertions in existing enactments. So basically that means wherever there is a bold wording that is in brackets, those words are being proposed that they are deleted from the act. And where words are underlined, it means those are proposed insertions. So that is just to guide the members as to understand as to what the bill is saying. Chairperson, I hope I covered all the issues you wish for me to raise.
Thank you, Ms. Isaacs. Can I then check from honorable members if is there anything that they would like to is it everything clear? Feel free. Don't be afraid, honorable members, to say, can she repeat this? I just couldn't pick that properly, because it's going to assist us. Now we are doing exactly the work that we then supposedly to be doing. But as one thing that she said, which was very important for me to note, was that, which I must first establish, do we all have, well, other people are IT gurus, do we have the bill with us, the one that was sent to be amended by the department? Do we have that as members? It was circulated, recirculated by the committee section. Do we have that, honorable members?
Yes, we do, Chair.
Okay. Is everybody?
Yes, Chair, we do have it.
Okay. And we do understand what Ms. Isaacs is taking us through on in terms of the general explanatory note. Okay. I think, therefore, when people are silent, it then means we do understand what exactly we are dealing with. I will then, what then I'm going to do, because now we are then starting our meeting, I will read what is in the bill up to a place where then I'm then going to then direct members if there are any comments, if we're in agreeing. Then the cover, which is the bold bill, to amend the Employment Equity Act 1998 so as to amend a definition, to insert certain definitions, to substitute a definition, and to delete a definition, to provide for the minister to identify sectoral numerical targets in order to ensure the equitable representation of sustainable qualified people from designated groups, and to provide for matters connected therewith. Parliament of the Republic of South Africa enacts as follows: amend of Section 1 of Act 55 of 1998 as amended by Section 40 of Act 65 of Section 202, Section 26 of Act 68 of 202, Section 23 and 25 of Act 52 of 203, Section 51 of Act 11 of 2013, and Section 1 and 2 of Act 47 of 2013. Now, members, then, I am then going to indicate we are in Section 1. Any comments? Any comments, honorable members? Miss Isaacs, I think I will then be correct if there are any comments in section 1. We will then get before that, Honorable Card, I see a hand, Honorable Cardo. Any other hand?
Thanks, Chair. I was just going to ask that could Zulani or somebody please put the bill up on the screen so that we can see it.
Okay. All right. No, that is in order. Mr. Sakaza, sorry for that. Mr. Sakaza.
Yes, Chair, I'm doing that now.
Oh, okay. Who is Kelvin Fodling? Okay. There is section 1. Any comments? On Mr. Isaac, Miss Isaacs, it will be correct of the chair. I'm just trying to it will be correct of the chair to then say if there are any, if members are comfortable with what is proposed, there will then be a mover and a seconder. Am I correct in each particular section?
Chairperson, not at this stage, because we're just going through the bill to see whether there's a proposed amendment. That will come only later on when we agree to whether there's going to be any proposals. So at this stage, it's just deliberation for members to raise any issues they may have.
Okay. Thank you.
Chairperson, maybe may I just suggest that Zulani also show the Employment Equity Act so members can see which section is being deleted in the so they're just clear as to what is being deleted.
Okay. I would also request because I don't know if members must feel free to say, can we be guided again? I'm a bit confused. I'm making an example. Members must feel free to do that because I wouldn't like as the chair to have people who felt excluded because of I know law is very intimidating. That's why Ms. Isaacs is here, and feel free to ensure that you follow the process. I would appreciate that, so that I don't preside over deliberations, and down the line I am then accused of having left people behind because they were a bit confused or ignorant on A, B, C, and D. So that's why even from myself, I always try to get guidance from Ms. Isaacs. Solana, what is happening now?
Chair, I'm just writing to Sue-Ann now to say I've made her co-host because I'm challenged when to share the both. I can only share one screen, one bill. So I was asking, I made her co-host so that if she can also assist me in sharing the other bill.
How are we going to manage Ms. Isaacs to show both of them in one screen? Is it possible?
Chairperson, I would think we could just use the tabs because I'm not, I don't have my bill on this device that I'm using.
Which bill are you referring to? Are you referring to the principal bill?
I don't have, yeah, I'm using a different device from my laptop, so I don't have it available to share on this device. If Zolani can just open the tabs between the tabs, because I just want members to be clear as to what is being deleted.
As I was saying, Chair, sorry to you, Chair, I can only share, I can show you, I can share only one screen, which is the what is this, the amendment bill, not the other one at the same time. That's my challenge, Chair.
Can I can I then propose that Miss, there's somebody who wants to speak?
Yes, Chair, I was, are you giving me an opportunity, Chair?
Your hand is not up.
Oh.
Honorable Mkondo?
Thanks, Chair. I was suggesting, Chair, good morning, Chair, honorable members and colleagues and guests. Chair, I was suggesting that since we have been dealing with this bill for quite a long time now, I think the amendment bill itself will be able to suffice as long as we are guided as to exactly what points must we focus on. Thanks, Chair.
Can I get another view before I ask Ms. Isaacs? Honorable members? Honorable Kado, Honorable Dana?
Thanks, Chair. I don't think we should just simply take the bill as given. We haven't had an opportunity to deliberate on it, and this is the occasion on which we are using to deliberate on it. So I do think we should go through it clause by clause.
Honorable Dana?
Thank you, Chair. I think for us to get the entire picture, the bigger picture of the amendments as a whole and the impact of them, I think it would be good if we could sit with both bills in front of us and compare them and see where the amendments are and then deliberate on them step by step.
Two things. I think one, because I wanted to check the understanding of members. One, I think Honorable Kado is correct. We don't just take it as is. We are to deliberate. That is why we were listening to everybody, including the department. So, for an example, in section 1, what is it that we are agreeing on? Do we agree with what has then been tabled? But again, we have got a problem, Honorable Dana, of technology, that if you put both, it is then going to be a challenge, which my understanding is that Ms. Isaacs wanted also the principal bill. Well, I don't think we're going to be able to do that. What we are then going to be able to do that is that in section 1, there are those that are in bold, up to the next page, which is page 3. What is then our view? Why do we think it is? I'm making an example. Why we think that it's correct as it was reflected by the department, or we think that it is not correct because of ABCD. I think that's what deliberation means. It's not just because we have been dealing with this, we'll then have to take things as they are. So my challenge is that the technology is not going to allow us to do that Mr. Isaacs, will it then be important that at least you then assist us in terms of section 1? Where should we be? What is it in section 1? What then becomes our role? Should we, and whatever what is in the bill, so that we are then able to, and members will then understand, will remember what then parties said in terms of that section.
Yes, Chairperson, I can just point out to the committee as to what is being deleted and what is being inserted, so members are clear on that. I do understand the issue with the technology makes it difficult.
Okay, over to you.
So Chairperson, the first clause is clause 1, and it seeks in the paragraph A. It says by the deletion of paragraph B in the definition of designated employer. So what is being proposed to be deleted is that designated employer means B, a person who employs fewer than 50 employees, but has a total annual turnover that is equal to or above the applicable annual turnover for a small business in terms of Schedule 4 of the Act. So that is being proposed to be deleted. So this Act will not, a company or an employer with 50 or less people will now be no longer defined as a designated employer. B is to insert the definition of minimum wage commission, and that is self-explanatory. It is now just to bring it in line with the Minimum Wage Act. The paragraph C is to amend the definition of people with disabilities. So if you see all the words that are in bold and in bracketed are being excluded, and the underlined words are now being included. So that definition is to bring it in line with the UN Convention on Disabilities. D is to insert the word sector after republic in the Act. That is also self-explanatory. And E is to delete the definition of serve and submit. So currently, the Act defines serve and submit in relation to any communications means that A, to send it in writing delivered by hand registered post, B, to transmit it using an electronic mechanism as a result of which the recipient is capable of printing the communication, or C, to send or transmit it in any other prescribed manner. So the proposal is to delete this definition of serve and submit, so to allow the minister to prescribe the way documents or anything in the Act should be served. So that definition will be removed and it will now be prescribed by the minister. That is the first clause, Chairperson.
Members, any comments? Okay, if there are any comments, can we then proceed to page 3? Can you also lead us?
Thank you, Chairperson. Chairperson, this clause, clause 2, seeks to amend section 8 of the Act, and it does this by deleting paragraph D in the existing Act. So section D currently deals with psychological testing and other similar assessments. And it says psychological testing and other similar assessments of an employee are prohibited unless the test or assessment being used, A, has been scientifically shown to be valid and reliable, B, can be applied fairly to employees. C, is not biased against any employee or group. Now, what is going to be deleted is the following paragraph. D, has been certified by the Health Professionals Council of South Africa, established by Section 2 of the Health Professionals Act 1974, Act number 56 of 1974, or any other body that may be authorized by law to certify those tests and assessments. So paragraph D, the certification by the Health Professionals Council is now being proposed to be deleted.
Any comments? Members are fine with that? I don't see any hand. You may continue, Mr. Isaacs.
The next clause is clause 3. Section 14 of the Principal Act is hereby repealed. Currently, Section 14 of the Act deals with voluntary compliance with this Act. And it says, an employee that is not a designated employer may notify the Director General that it intends to comply with this Act as it were a designated employer. So that is being proposed to be deleted. So there will be no voluntary compliance with this Act in terms of Section 14.
Any comments? Okay, none. You may proceed.
Chair, my hand is up.
Oh, sorry, I didn't see. Any other hand? Honorable Kaya.
Sorry, Chair, I'm struggling to put my hand up, but I would like to make a comment next after Honorable Cardo.
It's Honorable Cardo, Honorable Dana.
Chair, I would like to know why the voluntary provision is being withdrawn. I would have thought that we should be encouraging the voluntary nature of these matters rather than making them compulsory. Thank you.
Honorable Dana.
Yes, Chair. Thank you, Chair. Honorable Cardo basically summed up my question. I would like to know exactly what he said, why this provision is being changed. Let's just get that answer first, and then I'll take it further. Thank you, Chair.
Okay, I will then request the department to respond.
Thank you, Chair. The rationale for Section 14.
You only see the up your crown. Okay.
Sorry, Chair. The rationale for voluntary reporting was based on the assumption that employers who want to do BE deals would want to comply with the Employment Equity Act. Now, remember that those companies that will voluntarily report are those companies that are excluded, which will be companies that are smaller than or employ less than 50 or has got a different threshold less than 50. Now, with the changes that are being made in the system, that employers who do not report, who want to do maybe BE deals, who want a certificate, can get a certificate. Remember, in terms of the presentation that we gave, we indicated that employers who are not designated, if they want to get a certificate of compliance, they've got to answer 2 questions. 1, do they comply with the minimum wage? If they say yes, they will tick yes. They don't have to supply any information, they just tick yes. The second question is do they have a case at the CCMA or the Labour Court or the Constitutional Court that has been decided against the company on unfair discrimination? If they answer no in that question, then they tick no, then they are able to get a certificate. They don't have to report on anything. Therefore, there's no reason for people who are outside the law to voluntarily report, because everybody else must report. There's nothing voluntary about it. It's either you are designated to report or you are not designated to report. Those who are not designated to report, who need a clearance certificate that they can do transaction with government or any other department, they can answer those two questions that are simple, direct, instead of asking them to give a long report on their employment equity processes. But any other company that is designated is expected to report. Therefore, there's no need for volunteer reporting in terms of the system that is being introduced. And that's the reason that the change is being proposed. Thank you, Chair.
Thank you, Mr. Mkalipi. Honorable members, that is the response. Are you satisfied?
Thank you,
You
Chair.
want to propose something? Honorable Dana, I can't see your hand, but I hear your voice. I'm assuming you want to speak.
No, I just said thank you, Chair.
Okay. Honorable Kado?
No, Chair, I have no further input. Thank you.
You are clarified. Thank you. Next, take us through number 4. Honorable Ms. Isaacs.
Thank you, Chairperson. Clause 4 is to insert a section 15A. This is a new section into the Act. So it says determination of sectoral numerical targets. Clause 15A says as follows: 1, the minister may, by notice in the Gazette, identify national economic sectors for the purpose of this Act, having regard for any relevant code contained in the Standard Industrial Classification of all economic activities published by Statistics South Africa. 2, the minister may prescribe criteria that may be taken into account in identifying sectors and subsectors for the purpose of this section. 3, the minister may, after consulting the National Minimum Wage Commission, for the purpose of ensuring the equitable representation of suitably qualified people from designated groups at all occupational levels in the workforce, by notice in the Gazette, set numerical targets for any national economic sector identified in terms of subsection 1. 4, a notice issued in terms of subsection 3 may set different numerical targets for different occupational levels, subsectors, or regions within a sector, or on the basis of any other relevant factor. 5, a draft of any notice that the minister proposes to issue in terms of subsection 1 or subsection 3 must be published in the Gazette, allowing interested parties at least 30 days to comment thereon. So, Chairperson, as I said, this is a proposed new section that will be inserted in the Act if it's adopted by this committee.
Thank you, Ms. Isaacs. Honorable members, there is the proposed new section. Any takers?
Chair, my hand is up.
Ricardo, who's the next? Can I check? For
Chair?
Honorable Dana. Any other hand? What I will then request honorable members to, you will be listening to people who may be arguing against or for. So please, members, honorable members, deliberations are that it is red. I'm making an example. It is red. No, it is not maroon. I'm saying it's maroon because there has been a tinge of white that has been dropped into the, or a tinge of black that has been dropped into that, which then has, and whatever. This road is going to take us to point A. No, this road is short to take us to point A. It's important that we travel longer distance so that we're able to see ABCD. I'm just making an example. So those whose hands are up are to reflect their views, and those who are listening must then be able to say, no, I'm disagreeing with member X on that. For me, is that this new thing is in order. So I'm trying to make members to be a bit free. I must not get we're a bit tense, even if we are on virtual. Please, members, can we loosen up? Deliberations is about for or against, and yeah. So I see Honorable Kado, it's Honorable Kado, Honorable Dana. Can you put your views, honorable members?
Thanks, Chair. I would like to propose that this whole section actually be scrapped. I don't think that the Minister should have any business in setting numerical targets for designated employers in any national economic sector. I think this section gives the Minister far too much discretion, indeed untrammeled discretion, and that the guiding parameters are not sufficiently clear, and that, as we heard from many submissioners on this particular section, that 15A actually undermines the supremacy of the rule of law. So I think that this particular section is fatally flawed, and my proposal would be to have it scrapped. Thank you, Chair.
Honorable Dana.
Chair, I will not waste the committee's time by repeating everything that Honourable Cardo said, so I will just say that I agree with what he said, that this section should be scrapped in its entirety.
Thank you. Any counter views? I don't see hands. Can members, they will indicate?
My hand is up.
Honorable Mkonto, who else?
Sibusiso Mdabe, Chair.
Honorable Mdabe. Honorable Mkonto, Honorable Mdabe, in that order. Any other hand? Okay. Honorable Mkonto.
Chair, I think in this section there are things that are very important in as far as monitoring and accountability is concerned. I don't think it will be proper for this committee to give all powers to employers to be law unto themselves. I think government has a responsibility to make sure that there are rules that are being adhered to, specifically in the employment and labor sector. So, Chair, I support this section, specifically number 3, where it says the Minister may, after consulting the National Minimum Wage Commission for the purpose of ensuring the equitable representation of suitably qualified people from designated groups. There will be consultation, Chair. So I think this section is in order. Thank you.
Honorable Mkonto, Honorable Mdabe, and I saw Honorable Nonsele's hand. So Honorable Mdabe, then it will be Honorable Nonsele.
Thank you very much, Honorable Chairperson, and good morning to all the members. Chairperson, first and foremost is that the economic sector was given an opportunity to comply with the Employment Equity Act as it was enacted in 1998. The issue of then bringing up this new section was consulted at NEDLAC with all the social partners, and they all agreed that this is required in terms of meeting the targets and making sure that the minister does make the determination as far as targets are concerned. We must take, therefore, into account that the sectoral targets are important for regional and sub-regional demographic diversity. So therefore, South Africa being a diverse nation, it is often linked to geography. So it's important that this section gives powers to the minister for those sectors that do not want to comply. And they have already shown that they are not prepared to do so for the time given when the act was enacted. Therefore, we would make a submission as ANC that we support this section to be inserted in the amendments. Thanks, Chair.
Thank you, Honorable Ndabe. Honorable Nontsele.
Morning, Chair. Am I audible, Chair?
Honorable Nontsele.
Chair, I'm checking. Am I audible?
We can't hear you.
Yes, I'm trying to communicate.
Is it possible for you to put you are very faint. Is it possible for you to put it in the chat?
Okay, Chair.
Mr. Sakaza, can you phone Honorable Nontsele? We can't, and as he's struggling, is it possible to just to indicate what is in a short version, because we can't hear? If he can put that on a chat.
Am I audible now, Chair? Because I can hear you clearly.
Honorable Nontsele, we can't hear you at all.
Okay.
Mr. Sakaza. Mr. Sakaza.
Yes, Chair, I'm trying to send him the IT number so that he can contact them, because I don't know. Yeah, I'm sending Mr.
There's something I must correct. I don't know why your hand is up, Mr. Mens, because guests don't participate. Please, can you lower your hand? Can you lower your hand, sir?
Apologies, ma'am. I will do that. I wanted just to ask a question of clarity pertaining to the participation of the guests in these proceedings, but you have clarified that. Thanks.
No, guests don't participate. Whilst we are still sorting out Mr. Nontsele's hand, can I take Mr. Bagram?
Thank you, Chair. Thank you very much. It was said earlier on that all the parties to NEDLAC had agreed to this section. That's not correct. And I would suggest very strongly that we go and have a look at that very carefully, because it was not agreed. And there were a minority who did not agree to this. And I'd like to have a look at those minutes of NEDLAC and see what actually transpired there. In essence, I think it would be a good idea, in fact, to remove the duty from the minister to make a decision and put it into the hands of NEDLAC. We have NEDLAC there. They are, we all seem to agree that they are consulting very carefully with all the social partners and the players in the field. They are set up already. They are a very functioning group, and maybe they should be the ones to set the targets and not the minister. We know that the minister setting targets is going to be a disaster. So thank you very much.
Honorable Nontsele. I think we have got a very serious problem. There are two hands that are coming back, which is Honorable Kado. I don't know if it's old hands. Honorable Kado, Honorable Mdabe. I will come back to you, Ms. Isaacs. I see your hand is also up. Can I just get Honorable Kado and Honorable Mdabe?
Thank you, Chair. Look, I mean, I remain opposed to the section in its entirety, but if we are talking about the minister's right in particular and who should play a role in determining these sectoral targets, identifying and determining them, well, then what about the domain of us as parliamentarians? I mean, there is a strong case to be made that this should be the domain of legislators and that Parliament should decide the criteria. It's not a technical or implementation issue. So why not involve Parliament? And I put that as a question to the department. Thank you.
Honorable Mdabe.
Thank you very much, Chairperson. And it's a follow-up on the debate. The issue of the minister's powers is in line with the principle of consultation with all the relevant stakeholders. That's a principle that was established at NET. However, the issue of Section 15A as a whole is agreed to, that there would then be a process in the implementation of the minister's exercising his rights. Provisions requiring employers to consult trade unions and other stakeholders are welcome. And that's how the process has been. And they will help strengthen the issue of collective engagement and encourage labor market stability. It is important, therefore, that you don't find a situation where the labor is not being listened to or adhered to the views that they've been raised within the bargaining council negotiations in relation to the specifics that the employer is not complying with what has been determined. Thanks, Chair. I'm done, Chair.
Thank you, Honorable Mdabe. Honorable Dana.
Thank you, Chair. Now, I just have a comment. I hear what everyone is saying about consultation and the process of consultation and that there has to be consultation, but I think that it would be irresponsible for us as a committee to allow the sole power of unlimited and undefined discretion to be vested in one single person. There must be at least a defined framework of what empowers the minister to decide what he decides when he decides on these amendments. But I do stand with my previous comment that I think this entire section should be scrapped.
I'm still trying to establish Honorable Nontsele, because I don't see, I don't know whether can somebody call him and say if he, because he does have a right to write in the chat and then we read what he is saying in the chat. Honorable Nontsele, because his hand is still up. Honorable Nontsele.
I'm changing a gadget, but I've
We can't hear you.
Yes, Chair, I know that. I'm saying I'm changing a gadget. Can the technical people allow me in so that I use a gadget that will allow me in?
Oh, okay. Mr. Sakaza, can you please allow people, technical people to communicate with him, because if I pick him faintly, he's saying he's changing the gadgets. Can he be allowed by the technical staff?
Yes. I'm in there now.
There's a sound. There's a sound. Are you fine now?
Yes, Chair, I'm fine now.
Okay, over to you.
Can you hear me?
Now we can hear you clear.
Thank you, Chair. Good morning, honorable members and the public in general. I'm sorry for the inconvenience caused. Chair, I think most of the points I agree with that have been submitted by Honorable Ndabe. It's just further to emphasize the point that is contemplated in terms of Section 15A, that principally we support the formulation as it stands, but just one minor area for consideration is the area that refers to the National Minimum Wage Commission, because the area of consultation here would be essentially the Employment Equity Commission, which basically consists of both the social partners, that is business and labor and government, that deals with this specific area. So that's the area that one would just add on that. But overall, the submissions that have been made by Honorable Ndabe are in fact correct. In conclusion, Chair, I think the submission that says these are in fact far-fetched are in fact not just false, because the bill itself restates what in fact had already been agreed to by all parties, including the DA. That DA now is posturing on a wrong platform, in the sense that this is an expression that is in fact founded in the Constitution. And if then there is any view to the contrary to the views that are put forward, I think the essential point would be first for them to argue to change the Constitution, so that the Constitution does not talk about the need to address all the historical challenges that are associated with the imbalances in terms of employment at the workplace and the inequality that continue to characterize particularly the private sector. So that would be just the additional summary, Chair, I would make in support of the formulation, including the proposed change with regard to the National Minimum Wage Commission and instead the Employment Equity Commission. Thank you, Chair.
Thank you very much, Honorable Nontsele. Your apology is accepted. I hope now you are more fixed to move forward. Before I allow the department to respond on issues, can I just get a second on what Honorable Nontsele is saying in terms of point 3? The minister may, after consulting the National Minimum Wage Commission, but he's then proposing to say the Employment Equity Commission. Can I get a person who is supporting that?
I have my hand up, Chair.
Honorable Ndabe.
Thank you, Chair. I'm supporting that, and over and above that is then to say, considering the submissions and oral presentations, the following areas would have to be looked at, especially on Section 15.3A3, which include the consultation of relevant stakeholders and delete the national minimum wage. I'm not sure whether Comrade Nontsele was referring to that one, but that's a submission that I'm making. If ever he was referring to that, then I'm seconding it. Thanks.
He was referring to that. Is
The
there any
second.
person? Is there any person who's countering that? If
Chair, my
none,
hand up.
Honorable Mkondo.
I'm not against Chair. I wanted to say it makes more sense.
Okay.
Yes, it makes more sense when the Employment Equity Commission is the one that has to be consulted because it is the custodian of employment equity.
Thank you, Honorable Mkondo. Mr. Mkalipi, that's one that has been raised now. Two, Honorable Bagram was then referring to rather giving powers to the minister. Why is it that it is not then being given to NEDLEC? I hope you were listening to him, and I was just summarizing what he was raising. Can you then please respond, the department respond on these two areas that have been put across? Honorable Begram's comment on then and in fact, the third one was Honorable Honorable Kado was saying, why don't then that be given to Parliament to determine the target? Can the department respond on that, on those three?
Thank you, Chair. First, I mean, on the issue, the proposal raised by Honorable Nonele, that the minimum each should be replaced by the minimum, the commission, the Employment Equity Commission, is correct. It was a mistake that the bill referred to the National Minimum Wage Commission. In this area, it should refer to the Employment Equity Commission, and Honorable Nonele is correct in that. And the issue raised by also that he raised that the setting of targets should be done after consulting the sector concerned. Maybe the members can consider amending, as he has said, 1583, and Honorable Ndabe also supported that the section can read, the minister may, after consulting the relevant sectors and the advice of the Commission for Employment Equity, do what you need to do and make those changes. I think they are enriching the legislation in that. On the issue of why can't NEDLEC be given this, the NEDLEC deal with policy.
Sorry for that. In fact, he was saying it is not correct. There are other sectors that were not consulted in NEDLEC. Can you please also reflect on that? And I hope, Mr. Bagram, I'm quoting you correctly.
Well, at NEDLEC, we've got agreement on this bill. The only issue that was raised by NEDLEC parties who came to the committee was that in the agreement that was reached at NEDLEC, it was agreed that the minister will consult the sectors in setting the targets. And the bill as it stands now does not deal with that. And the proposal that is made by Honorable Daba and supported by Honorable is solving that problem, where it says that 15A3 must be amended to factor the effect that the minister must set up the targets after consulting the relevant sectors and with the advice of the Commission of Employment Equity. Therefore, that solved that problem. At NEDLEC, all the parties agreed on the bill as reflecting that consultation part. There's no party at NEDLEC that has rejected the bill. If there are parties, it will be parties that are outside NEDLEC. But at NEDLEC, it was agreed, the bill was agreed. The only issue, as I've indicated, that Busa raised in the public hearing was that part about consulting the sector was left out in the bill. And now Honorable Nokele is solving that problem. Therefore, we don't foresee any problem. And as I've said, NEDLEC is not an implementation institution. It's dealing with policy. Government implement. You can't expect NEDLEC. They do not have the power to set up targets. They do not have the power to go out and implement those targets. The department and the inspections that is set up, that reports at NEDLEC, on a timely basis, does the enforcement and the monitoring, and the minister setting up, and the issue of consultation with the sector solve that problem. There's no reason why the NEDLEC as an institution should be involved when the sectors that make up NEDLECs are included, Chair. Thank you, Chair.
The third one was, why not Parliament?
As I've indicated, Chair, is that Parliament deal with the laws. Parliament can call on the minister to come and in terms of the processes of setting this in the regulation that are published, the target is going to be published as a form of a regulation for the different sectors. There's nothing preventing Parliament and calling the minister and the department to come and talk about the target that they've set up, just like they will be published for public comments for the citizen of this country to also have a view on the target that are set up. If there's a comment that indicates that the target is too low or is too high, the minister will have to look at those. And also, as I've said, Parliament has got the authority and the power to call on the minister on the target that the minister has set up, for the minister to come into this committee and explain why set that target, not this target, what are the issues, and members of Parliament will be able to ask all of those questions in the minister setting when setting those targets. And Parliament, we don't think that Parliament will be able to set target, because as the proposal indicate, those targets must be set up with consultation with the other sectors. Thank you, Chair.
Thank you, Mr. Mkhaliphi. I hope the scribers are able to have been very attentive. I think also together with Ms. Isaacs, the deliberations around this section, noting the very important issues that have been raised, the proposals that have been accepted, and the responses from the department. So we are now, if there are any other comments on the matter, we will then request Ms. Isaacs to lead us on the next amendment.
Chairperson, I just had a comment on section 15A, with your permission.
Yes.
Chairperson, my comment is a technical legal issue. So, and this was raised in quite a number of the submissions. So if we look at clause 4 section, the proposed 15A1, the first number 1 says the minister may by notice in the Gazette identify national economic sectors for the purpose of this act, having regard to any relevant code contained in the standard industrial classifications for all economic activities published by Stats South Africa. So in terms of delegation, Parliament is delegating the power to identify these national economic sectors to the minister, and it is defining the limits of this power by saying the minister must look at these codes that are published by Statistics South Africa. My concern is with the subclause 2, which says the minister may prescribe criteria that must be taken into account in identifying sectors and subsectors for the purpose of the section. So it just, in my view, number 1 and number 2 are saying two different things, because now we're saying the minister may prescribe criteria, while in number 1, we've already told the minister that he must identify the sectors in terms of the codes. It is not clear what factors he will take into consideration in prescribing these criteria. So in number 1, Parliament guides the minister as to what to do, but in clause 2 or in subclause 2, there isn't any guidance. It just says the minister may prescribe criteria. Another concern is that if you look at subclause 5, it says a draft notice that the minister proposes to issue in terms of subsection 1 or subsection 3 must be published in the Gazette, allowing interested parties at least 30 days to comment. So we know that number 1, where he identifies economic sectors, must be published in the Gazette, but it's not clear where he identifies subsectors, like what will happen, whether the public will be allowed to comment. So my concern is that subclause 2 does not set the criteria and gives the minister complete discretion. So just want to caution the committee that we are giving the minister unlimited discretion to prescribe the criteria, and it contradicts number 1, because there we're telling him exactly what to do.
Mr. Mkalipi, any person from before you come in, any person from your legal team, or are you empowered to respond on that?
I'm empowered, Chair, to respond on that.
Yes.
Chair, I think I understand the issue raised by our colleague from the parliamentary legal. I think it makes sense, and it won't change anything. I think clause 1 is clearer, and it gives an indication that the minister can't just set up the sectors that State South Africa published, and State South Africa, in terms of sectors, is more experienced in terms of this, has got the capacity and the skills, has been publishing this code for a number of years. Therefore, deleting subclause 2 is not going to make any change in terms of the section as it is, and I understand the issue.
Honorable members, there is the response from the department that deleting 2 won't make or break any processes. Is there a formal mover in us deleting 2? Is there a formal mover in deleting 2? Honorable Mdabe.
Thank you very much, Chair. Considering what the legal team has advised in terms of the chronology of and the logic of the subsections of 15A, I therefore move that formally move that 15A subsection 2 be deleted.
Can we get a formal seconder? Any seconder, honorable members? Unfortunately, I can't second, but I will have to second. Any seconder?
Chair, my hand is up and maybe you can't see it.
Oh, Honorable Nkonto, sorry for that.
Yes, Chair, sorry for the delayed response. I've been reading, Chair, and I second. After reading all the subsections, I think removing a 2 will be okay.
Okay. Is there anybody who's against? By the looks, there is nobody, there's no indication, which then means, Ms. Isaacs, then section 3 becomes section 2, section 4 becomes 3, then 5 becomes 4. That numbering. I'm correct. Am I correct?
Yes, Chairperson, that will automatically happen.
Okay. I don't want to take you know how sensitive the issues of the bills, so the small things, you must just not take them for granted. Thank you very much, honorable members. Then we have got, we are then moving to leaders, Ms. Isaacs.
Thank you, Chairperson. We are now dealing with clause 5, which seeks to amend section 16 of the Act. Section 16 of the Act deals with consultation with employees, and 16.1 says a designated employer must take reasonable steps to consult and attempt to reach agreement on matters referred to in section 17. And A says with a representative trade union, with a trade union representing members at the workplace and its employees or representatives nominated by them. And then B says, if no representative trade union represents members at the workplace with its employees or representatives nominated by them. So the proposal is to remove the wording "and its employees or representative nominated by them," because it's also already covered in the following subsection in the Act. So it's just to remove that phrase.
Fine. Can you lead us? Can we move to the next session?
Sure, Chairperson. The next clause that is clause 6, which seeks to amend Section 20 of the Act. Section 20 of the Act deals with employment equity plans. So the proposal is to insert clause 2, capital letter A, and it says the numerical goals set by an employee in terms of subsection 2 must comply with any sectoral targets in terms of section 15A that applies to that employer. So basically that the employment equity plans now must ensure that the target set by the minister is now, they comply with the target set by the minister. Chairperson.
Thank you. Any comments? No comments. Ms. Isaacs, can we move to the next?
Thank you, Chairperson. We are now dealing with clause 7, which is the proposal to amend section 21 of the Act, which deals with report. The proposal is to amend subsection 1. It now will say a designated employer must submit a report to the Director General once every year. And the proposal is to delete the following words: on the first working day of October or on such, and to delete the word other date and to include the words and in such manner as may be prescribed. So if the proposal is accepted, it will read: a designated employer must submit a report to the Director General once every year on such date and in such manner that may be prescribed.
Thank you. Any comments, members? Next, you can take us through, Ms. Isaacs.
Paragraph B is the proposal to delete subsections 3 and 4 of section 21. And these are the current subsections. Subsection 3 reads: despite subsection 1, an employer that becomes a designated employer on or after the first working day of April, but before the first working day of October, must only support its first report on the first working day of October in the following year or on such other date contemplated in subsection 1. And subsection 4 reads: the report referred to in subsection 1 must contain prescribed information and must be signed by the Chief Executive Officer of the designated employer. Chairperson, those two subsections are proposed to be deleted.
Are proposed to be deleted?
Yes.
Members, that's the proposal. Okay. No comments.
The next subsection, the next paragraph is C, by the substitution of subsection 4 capital A for the following. So the 4A is, the new proposal is: an employer that is not able to submit a report to the Director General and to delete by the first working day of October. And then the words to be inserted are: period prescribed in terms of subsection 1 must notify the Director General, and we're deleting the words in writing before the last working day of August in the same year, and we're inserting in the prescribed manner and period, giving reasons for its inability to do so. So the proposal is to read as follows: an employer that is not able to submit a report to the Director General within the period prescribed in terms of subsection 1 must notify the Director General in the prescribed manner and period, giving reasons for its inability to do so.
Members, are you following? Are you accepting? Okay, can we move to the next?
Chairperson, the next is clause 8, and this is to proposal to amend section 27 of the Act. Section 27 of the Act deals with income differentials and discrimination. And the basic amendment is to include minimum wage, the minimum wage commission. So the proposal to section 1 is every designated employer, when reporting in terms of subsection 21, must submit a statement as prescribed to the and to remove employment conditions and to insert National Minimum Wage Commission. And then we'll delete that section says established by section 59 of the Basic Conditions of Employment Act on the remuneration and benefits received in each occupational level on that employer's workforce. The clause B will now be to amend subsection 3, 4, and 5. So subsection 3 will now read, the measure referred to in subsection 2 may include A, collective bargaining, B, compliance with sectorial determinations made by the minister in terms of section 51 of the Basic Condition of Employment Act and the National Minimum Wage Act, National Minimum Wage set in terms of the National Minimum Wage Act 2018, Act number 9 of 2018. C is apply norms and benchmarks set by the and to remove employment conditions and insert National Minimum Wage and Commission. D will read relevant measures taken in skills development legislation, or E to insert E, other measures that are appropriate in the circumstances. In subparagraph 4, and remove the words employment conditions and insert National Minimum Wage Commission must research and investigate norms and benchmarks for proportionate income differentials and advise the minister on appropriate measures for reducing disproportional differentials. Subparagraph of paragraph 5, the employment conditions, that words will be removed, and to insert National Minimum Wage Minimum Wage Commission may not disclose any information pertaining to individual employees or employers. So, Chairperson, this is basically to the amendments on a whole is to insert the words National Minimum Wage and just to align it with the National Minimum Wage Act now. So that is clause 8.
Next, honorable members, there is clause 8. Any comments? Thank you, Ms. Isaacs. Members will indicate if, okay, you can take us through.
Chairperson, the next clause is clause 9, and this is to amend section 36 of the Act. Section 36 deals with undertaking to comply. So the proposal is to substitute the words that are currently in the Act with the following. A labor inspector may request and obtain written undertaking from a designated employer to comply with paragraph A, B, and to insert C, then it's F, H, I, or J within specified period if the inspector has reasonable grounds to believe that the employer has failed to, and there's various factors that are listed currently, and the proposal in B is to insert a new C. So the labor inspector will take into the following factor into consideration. C, prepare an employment equity plan as required by section 20. So that is a new factor that will now be included in section 36 if accepted.
Honorable members, there is the proposal, the insertion, we insert C, and the wording of the proposed insertion. Okay.
So person, the next clause is clause 10, which deals with which proposes to amend section 37. Section 37 of the Act deals with compliance orders, and the current proposal is to subsection 1. It will now read: a labor inspector, or any person acting on behalf of a labor inspector may, and to remove the words issue and insert serve a compliance order. The word to will be removed, and to insert on a designated employer in a prescribed manner if the employer has failed to comply with section 16, 17, 19, 22, 24, 25, and 26 of this Act. B, by the substitution of subsection 2 for the following words, a compliance order, and the word issued will be removed, contemplated in terms of subsection, terms of will be removed. In terms of removed, subsection 1 must be issued by the labor inspector and must set out, and the current legislation sets out in detail what must be set out in that compliance order.
Thank you, Ms. Isaacs. Honorable members, there are the words that are to be removed and the proposed new insertions. Okay, take us through.
Chairperson, if I remember correctly, the department had a proposal on clause 10.
Come again?
Chairperson, I think if I remember correctly from when the department commented, they had a proposal on clause 10 to amend the wording.
Are you suggesting that there must...
I'm just reminding the chairperson that
there's something. What is that?
My hand is up, Chair.
Okay, I've noted you, Honorable Mkondo. Yes, Honorable. Yes, Ms. Isaacs. We will then request, before Honorable Mkondo speak, can we then request the department to read out?
Yes, Honorable Chair, my colleague is correct. There was a number of comments in the public comments that were open in Parliament about this area. And in our response to the comments, we indicated that we are able to accept the comment and leave the responsibility to the inspector and remove the word that we wanted to put in that says any other person acting on behalf of a labor inspector. Therefore, and we propose that if the members agree that section 37A remain the same, not be changed by adding that sentence that says any person acting on behalf of the inspector. We only remain with in the prescribed manner as a change in that section, Chair. The colleague is correct.
All right, Honorable Mkondo, your hand was up. Any other person? In the
I'm covered, Chair. That's what I wanted to ask as to, can we be given an example of such people? How qualified are they, and so forth and so forth. But now that it's going to be removed, I'm covered.
Okay. You formally move the removal.
Yes, Chair.
Can I get a seconder?
Sibusiso Mdabe, Chair, I formally second the proposal to remove the current amendment. Thank you.
Thank you. Any other person who has got a different view? Thank you very much. None. In the absence of that, can you lead us? Can you take us through, Ms. Isaacs?
Thank you, Chairperson. We are now at clause 11. Clause 11 seeks to amend section 42. Currently, section 42 deals with assessments of compliance. The proposal is to insert a new paragraph, A, capital A. So currently it reads, in determining whether a designated employer is implementing employment equity in compliance with the Act, the Director General or any person or body applying this Act may, in addition to the factors stated in Section 15, take the following into account. The Act lists various factors, but a new factor will be whether or not the employer has complied with any sectorial targets set in terms of Section 15A applicable to the employer. So this is to align the section with what is being proposed in the remainder of the Act or of the bill.
Thank you. Any comments, honorable members? None. Can you take us through to the next session?
My hand is up.
Oh, sorry. Honorable Kado, any other hand?
Chair, I just wanted to say that given my objections to section 15A, I also object to this particular section and would move to have it taken out.
You are objecting, you are saying the entire section 42 must be taken out.
I'm saying this clause 11, Chair, which is the one that is currently under discussion, which seeks to amend section 42.
Okay. Can we get any person who is in agreement with that?
Dinner, Chair. In agreement with Honorable Corda, sufficient.
Okay. Can we get a counter argument? But first, what are the reasons? Can we get so that the flow is consistent? Honorable Cardio, you say you want that to be, you're objecting to that. Is there a new?
In terms of my earlier objections to section 15A, Chair, and the fact that I think that it gives the minister far too much power, untrammeled power, and this particular section is intimately linked to section 15A, because basically, what this requires is that what the introduction of this particular clause says is that in addition to being measured against the demographic profile of either the national or the regional economically active population, they now also have to be measured against the employer's compliance with the sectoral numerical targets set by the minister in terms of the proposed section 15A. So there's a direct link between what clause 11 seeks to do and what the proposed amendments relating to the proposed section 15A do.
Dana, you are seconding within that context.
Yes, Chair.
Okay, can I get a different view?
Sibusiso Mdabe, Chair.
Honorable Mdabe.
Thank you very much, Chairperson. I think, Chairperson, as the bill stands, it will assist in seeking to address the legacies of discrimination. Two, I think it is fair, rational, and it empowers the state to deal with obstinate employers. Equally, it allows for regional diversity, which is a matter requiring sensitivity and links with good labor practices. Therefore, as the amendments as they currently stand, with the deletion of what has then been presented to us by the state law advisors and parliamentary legal advisory team, and the responses by the department in terms of agreeing with the whole process. I therefore move, Chairperson, that the bill as it stands with the amendments and deletions be approved by us. And I therefore support what is being presented to us. Thank you, Chair.
Any other taker?
Chair?
Honorable
Yes.
Mkhonto? Honorable Nonsele?
Chair, as we were listening to parties making inputs, making submissions, in as far as this is concerned, it was in most cases referred to the Constitution of the Republic. And we asked questions as to why do parties feel that this section is unconstitutional? Unfortunately, Chair, we couldn't get, as a committee, a satisfactory answer to say exactly why would we consider as a committee that this section is unconstitutional. So, Chair, I support that this section be left as it is, because Chair, looking at it, it is abiding by the Constitution of this country. Thank you.
Nonsele?
Honorable Chairperson, I am covered by both honorable members, and in this instance, I would second the motion as moved by Honorable Ndaba. Honorable Nonsele supports the motion. Thanks, Honorable Chair.
Thank you. Sorry for that. If there are any other views, can you then lead us to the next section, Honorable? I'm sorry, Ms. Isaacs.
Chairperson, just before we proceed, I just want to suggest or propose to the committee that we clean up the wording. It doesn't change the essence, it's just to make it neater. So instead of saying whether or not the employee has complied with any sectorial target settings, terms of section 15A applicable to that employer, I propose we say whether the employer has complied with sectorial targets set in terms of 15A applicable to that employer. It's just a technical, to make it sound better.
Okay, Mr. Mkhalipi?
Thank you, Chair. It does sound better when you take out the or not, because when you put the question whether the employer has complied, you're looking at whether they have complied or have not complied. Therefore, it makes sense to accept the amendment to that amendment to read whether the employer has complied with sectoral targets set up in terms of Section 15A applicable to that employer. Thank you, Chair.
Thank you. To those members that have agreed that the section must not be deleted, are you in agreement with the tidying up?
Chair, can Ms. Isaacs be given an opportunity to repeat what she was saying?
Ms. Isaacs?
Thank you, Chairperson. So the proposal I'm making is to remove the word or not and the word any. So it will read whether the employer has complied with sectoral targets set in terms of Section 15A applicable to that employer. It doesn't change the essence, it's just to tidy up the English.
Okay.
Supported, Chair.
Supported, Chair.
Thank you. Take us then when clause 12.
Thank you, Chair. We are in clause 12. Currently, the proposal is to insert a new sub 6 into section 53 of the Act. So section 53 deals with state contracts, and the proposed sub 6 will now read: the minister may only issue a certificate in terms of subsection 2 if the minister is satisfied, A, the employer has complied with numerical targets set in terms of Section 15A that applies to that employer. B, in respect of any target with which the employer has not complied, the employer has raised a reasonable ground to justify its failure to comply, as contemplated in Section 42(4). C, the employer has submitted a report in terms of Section 21. D, there has been no finding by the CCMA or a court within the previous 3 years that the employer breached the prohibition on unfair discrimination in Chapter 2. And E, the CCMA has not issued an award against the employer in the previous 3 years for failing to pay the minimum wage in terms of the National Minimum Wage Act 2018, Act number 9 of 2018.
Thank you. That's a new proposal. Any comments?
Yes, Chair.
Honorable Kado.
Thank you, Chair. Yeah, I've got a number of problems with this particular amendment. The first one is with the very first sentence, which uses the word satisfied. The minister may only issue a certificate in terms of subsection 2 if the minister is satisfied. Satisfied seems to me an extremely vague and potentially dangerous word. What does it actually mean? What are the grounds which the minister can be satisfied or not? What constitutes satisfaction, and what are the constraints on such satisfaction? Then secondly, I recall that one of the submissioners suggested that this particular section would introduce additional procurement costs for the state, and I wondered whether the department had a response to that. And then thirdly, I also recall that another submissioner, I can't remember whether it was Boost or maybe the Banking Association of South Africa, said that it was a very bad idea to mention the CCMA and such like in this particular section. In other words, what the bill tries to do here is to link compliance certificates to CCMA outcomes, and that is a bad conflation for various reasons which they gave at the time. CCMA cases may drag on for a very long time. They may be infinitely disputed, and therefore there was a big fat question mark raised about whether it's such a good idea to have the compliance certificate linked to CCMA outcomes, and I wonder whether the department has a response to that. Thank you.
Thank you. Any other comments before we allow the department to respond?
Chair is Mkonto.
Honorable Mkondo, who
Chair,
else?
my hand is up as well.
Honorable Nonsele.
Nonsele.
Yes, I've noted you. It's after Honorable Kado, it's Honorable Mkondo. After Honorable Mkondo, it's Honorable Nonsele. In that order.
Chair, the section itself, Chair, is supported, but then I just want some clarifications here and there, and to say I also have a challenge with that word satisfied, as Honorable Kado has alluded to. If that can be explained as to exactly, does it mean what we are thinking or not? And then, Chair, subsection B, the reasonable ground, the employer has raised a reasonable ground. I think also that one it's vague, Chair. It will be very difficult to monitor and evaluate such a situation from my point of view. If those two, Chair, can be clarified to us, or maybe we get words that can be up to the point and concise, that will be my suggestion, Chair. Thanks.
Honorable Nonsele.
Thanks, Honorable Chair. Thanks, Honorable members. Honorable Chair, my proposal is to move a motion for the acceptance of the proposed formulation with the additional amendments on 12D. 12D reads, there has been no finding by the CCMA or a court within the previous 3 years. The proposal is for the replacement of the 3 years to 12 months, so that it reads that there has been no finding by the CCMA or a court within the previous 12 months that the employer breached the prohibition of unfair discrimination in Chapter 2. Then on E as well, the CCMA has not issued an award against the employer in the previous 3 years. Again, the proposal is that we change it to read, the CCMA has not issued an award against the employer in the previous 12 months for failing to pay the minimum wage in terms of the relevant act, that is the National Minimum Wage Act of 2018. Yes. So that's the motion I would move, Chair, for the adoption of the reactivating, in fact, of Section 53, because in the Principal Act, the Section 53 has been already been enacted. It's not a new provision to the Principal Act. It's in fact already there. So most of the submissions that are made in fact as in such a way that they represent it as a new proposal, when in fact it's an already existing provision in the Act, except for the areas, Chair, that I'm proposing that they should in fact be reformulated in terms of the timeline, so that they fall in line with the applicable rules, particularly the CCM rules, in terms of their findings. So I move the motion, Chair. Thank you, Chair.
I hope the department has just to recap. One, what does minister is satisfied mean? Means reasonable ground. Two, then a proposal in terms of the timeline of a change that instead of 3 years, it must be 1 year. Mr. Mkalip?
Chair, I did have my hand up.
I didn't see you.
Also, Chair, my hand is up.
Oh, sorry, Honorable Bekram, Honorable Nkabani. Sorry for
Thank
that.
you. No problem, Chair. I'm quite ethereal, so I don't have a problem with it. In essence, I have certain problems. Obviously, you know, when they're in terms of B, where you have the employers raise a reasonable ground to justify its failure, well, I mean, it's for the minister to decide again. It's for someone to make an arbitrary decision with no grounds. I mean, the minister might say, I've had a bad day, so I'm not accepting these reasonable grounds. I don't understand that. And then when you look at D and E, the problem that you've got there is that the CCMA often makes awards that are overturned by the Labour Court. Now, to overturn it by the Labour Court, you have to go on review. Going on review can take you 2 to 3 years, which means that if in fact an employer has been found to do something wrong by the CCMA, or that might be found at a later date to not be any wrong, because many of the commissioners are not lawyers, then that person will not be able to get their certificate for anything up to 3 years. And the reality is the problem we've got is that without that certificate, people won't be able to do business. So all you're trying to do then is destroy business, which is well and good, because then you'll also destroy jobs. And as you know, that we've got that problem. So everything we're reading here, in fact, throughout, there's a golden thread throughout of this, is to destroy jobs. I'm not sure why we want to do that, but thank you.
Honorable Nkabani.
No, thank you, Chair. No, Chair, I just want to support what Comrade Nontale has raised in the meeting. The point that I want to speak to is the point that Comrade Kajo raised in the meeting, to say for him, I think it's 6. It's amendment of Section 53, Act 55 of 1998, but it's paragraph 12, Section 53 of the Principal Act, but that part that is having 6 as a number, which reads as the minister may only issue a certificate in terms of subsection 2 if the minister is satisfied that. Then the issues are then listed below. Chair, when you look at this broader term, which is satisfied, in terms of the South African English, it then means that when the minister is satisfied that all the adequate, is satisfied that that particular company or organization adequately meet or comply with a condition or obligation or demand that has been put into this act, Chair. It then, what I'm proposing is that let's just leave this provision as it is. I support it. Thank you.
Thank you, Honorable Nkabani. Mr. Mkalip, can you come in?
Thank you, Chair. I think, Chair, what is important that the word satisfied there does not stand on its own. The minister cannot be satisfied by anything else other than whether one, that the employer has complied with the targets. Remember, the minister sets the targets, the employer complied. The minister must satisfy himself that has this employer complied with the target. If the target is A, the employer has complied with A. There's nothing else that the minister can be satisfied with. B, in respect of any target with which the employer has not complied, if the employer has not complied with the target and the employer has got a justifiable reason for not complying with that target. And if you look in our regulations, the regulations that are published, that were published with the bill, that are agreed at NEDLAC, has got a list all justifiable reasons that an employer can use as a reason for not complying with the law. And the justifiable reason is it's a number of them. They're about 10. They include whether the economy has grown in that year. It could be a situation that in 1 year the rates for the COVID and is high, and we've got a lockdown, and employers have not been able to operate. Therefore, it affected the economy. The employer can say that the economy has been affected, therefore I was not able to justify that, obviously. And when the employer tick that justifiable reason, they get certificate up front immediately. They don't wait for the minister to say, I accept. And that certificate can only be withdrawn if after discussion with the employer, the inspectors find out the employer has lied in the justifiable reason. Therefore, and also what I'm trying to say is that the minister cannot be satisfied by anything else by all the issues raised in A, B, C, D, E. Those are the issues that guide the minister on his certification. It's not about he woke up this morning very happy at home, or he has eaten very nice food, therefore he's satisfied. No, it's about A, it's about B, it's about C, D, E, all of those issues. That's the first issue. The second issue, in the CCMA, this section says, has then been a finding? If there's no finding at the CCMA, there is a case, but the CCMA has not made a finding. It cannot be held against the employer, even if that case takes 20 years at the CCMA. That's the first thing. If the CCMA has got a finding, and that finding is taken to the Labour Court for review, that honourable member would know it keep the status quo. Therefore, the employer has no finding, even if the CCMA says the employer is guilty. But if the employer has taken it to the Labour Court, the Labour Appeal Court, the Constitutional Court, that decision of the CCMA is not implementable. Therefore, because of the fact that it's been challenged in court. And that's how this operate. If there's no decision final decision by CCMA or a court of law, remembering that decision of the CCMA, when they are taken on review, the status quo remain. And the reason also the issue that Honorable Lukwele is raising on the 3 years, that it should read the 12 months, is because employers are assessed on the basis of 12 months on their reports. They are expected to report on an annual basis. Therefore, the department and the minister must assess their compliance with the targets that have been set on an annual basis and not over 3 years. And that's why the change that Honorable Lukwele is making meet with the requirement. The law already requires employers to submit reports on an annual basis. Therefore, to wait in assessing those reports for 3 years, it defeats the purpose. Why ask employers to submit report for every 12 months and then assess them only in 3 years' time? And those are the issues. Therefore, from where we're coming from, honorable members, is that minister can only be satisfied by the categories that are listed A to E. An employer has complied in respect of the target, the employer has submitted the report, there has been no finding at the CCMA has not issued an award against the employer on the previous 3 years. All of those issues, that's what the minister must be satisfied about. And therefore, there's no room for minister thinking outside those areas that are stated in that section. When you read that section, that's what it says. And we think that it covers, the minister wouldn't have any space to go outside the parameter of that section. And the reason we accept that an employer must be able to be given a right to justify why they have not complied with the law. Because if there's a justifiable reason, for whatever reason, the employer, as I've said, maybe what we can make it clear on this, and we say if there's no, the employer has raised a justifiable reason, a reasonable ground to justify as prescribed, allow the minister to prescribe, because we've put them in the regulation already. What are the reasons? And NEDLAC has agreed on those. Businesses look at all of them. They were happy with the regulation as put in terms of the justifiable reason that indicate all areas that could influence an employer not being able to justify to implement the target. Thank you, Chair.
Thank you, Mr. Mkonto. I'm sorry, Mr. Mr. Mkalipi, that is then, members, what has then been explained.
Can I raise a point of clarification, Madam Chair? Michael Bagram?
Yes, sir.
That's not the way this reads. I understand what Mr. Nkalipi is trying to say, but it's not the way sections D and E read. It says if there's been no finding by the CCMA or a court, in other words, there's an award or a finding of the CCMA or court. We can put in this subject, this would be subject to an appeal, and then you have to issue the certificate, appeal or review. And it's exactly the same with number E. It says the CCMA has not issued an award. If the CCMA issues an award, and then you take that on review, it doesn't automatically put it on hold. That doesn't stand in law at all. So the wording is wrong. I understand what Mr. McLeapy is saying, and that would make matters a lot easier and better, but then we must change the wording, and the wording must be unless subject to an appeal or review. And as soon as the employer puts in a review application, then you must say that the award then has to stand aside. But that in law at the moment, that's not how it works. It doesn't automatically stand aside. And in fact, the deputy sheriff every day goes to people and said, there's an award. And I'm going to put that award to terms and actually attach goods. I don't care whether you've gone on review or not. And unless you've got a court order saying that I'm going to put that on hold, and you would get the court then to put it on hold, that's a different story. So Mr. Mklipi is all very well and right, but in law he's wrong. But I wish he was right. And so I'd like to change the wording there if possible. Thank you.
Mr. Honorable Baker, I've noted you, Honorable Mkondo. Okay. Honorable Baker, if you want to propose a rewording, please do that. Not all the other things that you are saying. Say, D, I'm proposing that it be reworded like this. C, I'm proposing it must be reworded. Please, no other frills that are being put. Just put so that we put that in the committee.
Okay, I'm happy to do that.
Please, I'm humbly requesting that, because when you are a bit long-winded, if I can put that, you then confuse the people that are to describe straight to the point. Whilst you are busy writing and you are going to read it, can I hear what Honorable Mkondo is going to say?
Chair, subsection D and E, referring to the CCMA and the courts, knowing our status quo in the country, Chair, only few employers would be in a position to subject only few employees will be in a position to subject their employers to CCMA or even the courts. Only few, Chair. So I don't know how can we put it to encourage employers to comply with labor laws and practice to have good labor practices. To put it that if they don't comply with labor laws, generally comply with labor laws, or have good labor practices, because that is at the lowest level where many activities of mistreating employees is happening. It's just that, Chair, I don't know exactly how that can be put in it to be able to cover even those employees that are having limited capacity to put their employees to the CCMA, to report their employees to the CCMA and the courts. Thanks, Chair.
A proposal. Whilst Honorable, before the department responds, once the Honorable Bagram is done with his proposed rewording, we allow Ms. Isaacs to take us through, and then we're going to come back to this one. Will that proposal, Ms. Isaacs, fine?
Chairperson, you're proposing that we continue and come back to a close
Yes,
trial?
because Honorable Bagram is going to make, not unless this has also got a bearing in other proposals that are to come. Then we have to wait for him to submit this proposal, see if members are agreeing or not agreeing, and then we move.
No, Chairperson, we can proceed. I don't think there's going to be an issue with that.
He is then saying, unless subject to an appeal. In his chart,
Honorable Chair.
Honorable Nonsele.
Yeah, my hand has been up for quite some time.
Sorry, good people. I have got a document in front of me, which is then making it difficult for me to see whose hand is up or not. Not unless yeah. So I see your hand, Honorable Nonsele. Are you on proposals by Mr. Bagram?
Yes, Chair. Maybe let's allow him to present it so that I don't speak past him. Yeah.
Okay. No, that's
then
fine.
I'm afterwards.
Honorable Bagram.
Thank you. I have presented it in the chat line. You'll see I've said unless subject to an appeal or review. That's it. For both D and E.
Where do we insert unless?
Straight after D and straight after E.
That is the proposal. Honorable Nonsele.
Honorable Chair, can we ask Honorable Bagram read it in the context of the sentence?
Okay.
Rather than to say straight after D and straight after E. Can you read just maybe, even if we can use just one as a reference point, either D or E, so that we get exactly what he wants to say.
All right, Honorable Bagram.
Thank you. I can put it into the sentence then. Let's read D. There has been no finding by the CCMA or court, comma, unless subject to an appeal or review, comma, within the previous 3 years that the employer breached the prohibition or unfair discrimination in Chapter 2. Number E, the CCMA has not issued an award against the employer in the previous 3 years for failing to pay the minimum wage in terms of the National Minimum Wage Act 2018, Act number 9 of 2018, unless subject to an appeal or review.
Okay. Procedurally, can I proceed? I mean, in terms of meeting procedures, can I get a seconder to that? Is there anybody who's seconding the reformulation?
I will second the reformulation, Chair, notwithstanding the fact that I have an overall opposition to this section.
Okay. Can we then get a counter? Anybody who is...
Yes. Honorable Chair.
And who else?
Honorable Mkondo.
Honorable Mkondo. Yes, Honorable Nonsele, you can proceed.
Honorable Chair, the proposal is the formulation is appreciated, but unfortunately, it just complicates the both sections, because it now creates almost uncertainty in the sense that the parties would now be dependent on the attitude of particularly the employer side to decide whether or not to take such findings under review. So the rights of taking of any award to review are already vested with the parties. There is no reason for us to in fact, to further entrench them because they are already entrenched. So writing them here would now complicate and create a doubt in the intentions of these provisions. The second point is that in terms of the roles, as you have properly followed even now, that there was a motion that I moved on this, and it was seconded by Honorable Ngabane. So if perhaps we can, as we consider this proposal by Honorable Bikram, understand that already there was a motion moved and a motion seconded. And my contention, therefore, with regard to the submission by Honorable Bikram is that this will further complicate because the areas that he in fact proposes are already entrenched and their rights vested with parties. So you don't have to rewrite them again. Thank you, Honorable Chair.
If there is a mover in deliberations, if there is a mover and a seconder, and if there are parties that have got a counter, it's a process that you'll have to allow, so that you don't then become rigid, because that will then create a serious problem, which then I will humbly request that we have done very well, we've been tolerant of one another. So I get your point, but if a party wants to come back and rework and whatever, and even if parties are creating a confusion in this, because one member of a particular party will say, I disagree, this whole thing, this whole section must be deleted, and the other one suggests a reformulation. We'll have to find some clarity on that. I'm trying to say, honorable members, a process of deliberations just request us to be a bit patient with one another. After Honorable Nonsele, it was Honorable Nkondo, or
Thanks, Chair. What is being raised by Honorable Bikram is, to my view, will complicate even more what I've raised earlier on, Chairperson. If more possibilities are being given to the employers and the employees that are at a certain level of understanding their rights and have a capacity to take the employers to the CCMA and the courts. If we put this phrase, Chairperson, it is going to be even worse. That is why I am not for the phrases to be added. Thanks, Chair.
Honorable Ngabane. Honorable Ngabane, is your hand up or it's an old hand? Honorable Ngabane, let's take that it's an old hand. Can somebody check here for me? Ms. Isaacs? Oh, I'm sorry. I think the department has already responded and there was a mover to that. Can we then move? Honorable Bikram, is it an old hand?
I've taken my hand down.
Okay, thank you. Honorable Isaacs? I'm sorry, Ms. Isaacs?
Chairperson, I just want to clarify. the committee is okay with the phrase, the minister is satisfied, because the sentence could work without that if members are still uncomfortable.
Well, I think now remember that we are deliberating. The department has explained why satisfied, and then what was then something that was agreed and moved, and the department was also comfortable with that, is within the previous 3 years, it was then changed the timeline to 12 months. And then there were these additions. So I don't think there is anything that, for now, we have listened to what the members have said. Let's move as we have been moving before, so that we don't, yeah. Can you then take us, because now at least Honorable Bagram has made it easy by just reading that, which has then not been agreed by some members. But can we move?
Sure, Chairperson. We are now dealing with clause 13, and clause 13 repeals proposes to repeal section 64A of the Act. Section 64A currently provides for amendment of annual turnover thresholds in Schedule 4. So it says the minister may, after consultation with the commission by notice in the Gazette, amend the annual turnover thresholds in Schedule 4 in order to counter the effects of inflation. So this amendment is linked to the removal of the definition of designated employer. So this is across amendments.
Okay. Any comments? I think we have then come to the end.
Sorry, Chair, there's just 3 more short clauses.
Okay, sorry for that.
So then the next clause is clause 14, which is to repeal Schedule 4, and Schedule 4 is setting out those turnover thresholds that was referred to in section 64A. And then the next clause is clause 15, which is to delete various footnotes in the current acts which are no longer applicable. Chairperson, those are the amendments. And then the last clause is the short title and commencement. And clause 16 reads, this act is called the Employment Equity Amendment Act 2020 and takes effect on a date fixed by the President by proclamation in the Gazette. Thank you, Chairperson. Those are the amendments.
Thank you, Ms. Isaacs. Any comments from members? Ms. Isaacs, now we will then table in the next meeting what is called the A list on every areas that have been agreed and proposals that were made for changing. That's what we are then going to do tomorrow. Am I correct?
Yes, Chairperson.
And that will be that. And then after that, we are then going to, then a report is then going to be formulated by the committee section for that to be adopted by the committee. Because remember that we are still going to go and debate and table this in the National Assembly chamber for the adoption by the House.
Chair?
Honorable Mkondo?
I'm very sorry to disturb you, Chair. I just want to get exactly what is expected of us tomorrow.
Ms. Isaacs?
Thank you, Chairperson. So, Chairperson, the committee has made made various proposals, which has been agreed to. I've just noted them with regard to the wording and, for instance, one of the clauses changing the time period from 3 years to 12 months. So all of those amendments now must be presented to the committee in what is called the A list. So the committee will be considering those proposals that has been accepted today. And once that has been agreed to tomorrow, then we will be able to produce the B bill. And in the next meeting, as you indicated, that B bill will be adopted by the committee with the report. Not tomorrow, in the meeting that follows after tomorrow.
Okay. Clarified, Honorable Mkondo?
Thanks, Chair.
Okay. Okay, I think, thank you very much, honorable members. Thank you very much, Ms. Isaacs. And I think we have done very well. In particular, the members who are on in their first term, and I'm very happy. To be honest, I was a bit panicking because this process is a very complicated. So you are, as members of the legislative arm of the state, you are tops. And my apologies to guests, that guests are just to listen. They are not to participate in the processes of the sitting of the committee. Their time has come and gone, which was when there were deliberations that were. So my apologies to the gentleman who wanted to participate. Can I suggest, Mr. Sakaza, that tomorrow's meeting starts at 10, and obviously Ms. Isaacs will be with us, and it then means between now and tomorrow, 9 o'clock, the committee staff. In fact, if it is possible, I don't think there are too many issues. Can we get that by the end of the day? The A list, Mr. Sakaza, working with the parliamentary legal person and your content advisor and the researcher, can that be formulated and be circulated to members before the end of today? Agreed?
Yes, Chair, we will contact we will sit together and then see what we can do. Thank you.
Thank you very much, honorable members. You have been stars, and at least you must pat your backs. You have done very well. So nobody's saying thank you.
Thanks, Chair.
Oh, thank you, Chair. Thank you, Chair.
So you are not quite sure. You are not confident of yourselves.
Where's Comrade Kado?
Comrade Kado.
Comrade Carter, and also the chair called me Kader earlier. Yes.
In myself also, my apologies. No, thank you very much, honorable members, because it also, today's process also reflected what should I say, political and ideological maturity of understanding one another. We will differ. There's nothing wrong with that. We can throw our tantrums. For me, it's how we do it, but I think you have done yourself, must pat your backs. Thank you very much. We meet again tomorrow at 10 o'clock, please, Mr. Sakaza.
Yes, Chair. No
Bye, Chair.
Bye.
Bye, Chair.
Mr. Pegram, I got my shot day before yesterday. And how far are you? Michael, is he gone?
I think he's gone, Chair. Is he gone? Yeah, he's gone.
Okay. So bye.
Ending the meeting now. Thank you. Bye.